that, I'll yield to Mr. Schock of Illinois.
Thank you, Mr. Chairman. Before I begin my question, I think I would just say that I think the chairman has been more than accommodating, more than outreaching to the other side. In fact, the chair would indulge when we had our first hearing where we invited witnesses who were victims of targeting. The chair asked for witnesses from the minority, and would the chair remind us how many minority witnesses were submitted?
There were none.
Thank you. Mr. Werfel, welcome.
Thank you.
On page 14 of your report that you've submitted to this committee, you outline a proposal to eliminate the backlog of certain 501c4 applicants that are currently before the IRS. You specifically suggest that to eliminate this backlog, you ask for these 501c4 applicants to certify under penalty of perjury to the IRS that no more than 40% of their expenditures and volunteer hours will go towards political campaign activity, and that the remaining 60% would go to the promotion of social welfare. If that is certified by the 501c4 applicant, it is your policy then that the applicant would be approved in the next 2 weeks.
That's correct.
I'd like to bring your attention to a specific case and ask for how that would fall under this category, specifically the 60-40 rule that you're proposing.
Is this a hypothetical case? Or?
No, this is a real live 48-hour-ago case.
Well, I might have difficulty in answering it if it's about taxpayer.
On Tuesday, the President unveiled his plan to cut greenhouse gas emissions. Within hours, millions of emails were sent to his re-election campaign supporters through BarackObama.com, the URL owned by Organizing for Action, a 527 organization. Within the email, it asks on its volunteers to, quote, call out via Twitter, email, letters, Facebook, and so on, members of Congress who are so-called, quote, climate change deniers. The action item doesn't just suggest they should educate, but rather that they should call them out. It then links to 85-plus members of Congress that they would like to be targeted, all of whom are Republican, many of whom are on this committee. Under that circumstance, I'm wondering whether or not that activity, those hours, and that money would be classified under the political campaign activity or under the promoting social welfare category.
Well, it's a good question. You're getting into a territory where I'm not the legal expert, but I will do my best to provide some clarity as far as I understand this and the rule of law here. It's my understanding that political campaign intervention has to do with, and I'm answering these questions as a broad matter because I don't want to get into 6103 issues or the specific taxpayer. So I just want to qualify that my answer is in the broad context of how we think about political campaign intervention. That it has to do, and the key issue is is the entity seeking C4 status attempting to influence the outcome of an election by either supporting a particular candidate or opposing a particular candidate. And the Federal Election Commission has provided guidance to help us on that. And when you have a situation in which, for example, an ad mentions a candidate within 30 days of an election, they say, well, there you go. At that point in time, you have political campaign intervention. But if they mention that candidate 120 days before an election, it's not as clear and more work needs to be done. So to get to your question, I think as a broad matter, one of the first questions I would have in analyzing it, and I think the lawyers who are experts in having that was, is there a candidate involved, and is the activity intended to influence the outcome of an election?
Well, there's 85 members of Congress specifically targeted.
Well, again, now you're getting into, I don't want to get too specific.
Well, I understand you don't want to get too specific, but the point I'm attempting to make is that the rule you're proposing requires the applicant to make a determination.
Correct.
And so as the commissioner of the IRS who's proposing the rule, under not a hypothetical but a real case situation, if you can't make a determination, how can we then ask a non-attorney, non-IRS commissioner, non-IRS employee to make that same determination under penalty of perjury to classify their activity as either advocating for promoting social welfare or political campaign activity if we're going to limit it under a 60-40 rule.
Right. I was talking at a very general level. There are specific guidance that that we can provide in our application and in the self-attestation. We ask the taxpayer to look at and determine whether they're meeting the criteria. You know, right now, me articulating it to the taxpayer, it's actually done in much more specificity in the materials that the taxpayer receives in terms of exactly how to answer those questions. I mean, so again, it has to do, the key issue is, are they attempting to influence the outcome of an election? Now, you take it from there and you do further analytics, and then the taxpayer can help determine whether they believe their expenditures will go higher than 40% for those types of activities.
All right. I realize my time has expired. I would just like, if I can, follow up from the IRS on exactly how this new rule would then be enforced. Whether it be additional auditing, whether it require additional personnel to enforce, and all of that.
And I can provide for the record the more specific guidance that we give the taxpayer.
Right.
It was just handed to me, but it might not be in the best interest to read it out loud.
No, I think you can submit it to the committee and we'll make it available. Mr. Paulson's